EU delegation in Kenya. Mr. Baron, feel most welcome, and we are attentive to your presentation.
Thank you. Ladies and gentlemen, Dr. Ruth Aora, Vice Chancellor Professor Isaac, Ms. Flora Bidali from the NLAS, and Ms. Mercy Mugue from the Council for Legal Education, friends from UNDP, Dan online and Francis, and all distinguished guests today, good afternoon. I'm very pleased to be here today with you. It's the second time I attend this conference. I was there also last year online, so I'm particularly pleased to be here physically present with you today. And I would really like to congratulate Egerton University and the Faculty of Law Legal Aid Project and all the partners involved in Kenya for supporting the organization of this conference. It gathers a wide range of stakeholders from so many different backgrounds, and the agenda looks particularly interesting. I think the titles of the papers looks really, really great. So to all of you who are presenting papers this week, congratulations. We really are looking forward to listening to the discussions and to reading the papers and see how this can contribute to the wider discussions we're having. For now, I will try to stay on topic at hand for this morning and address basically 3 points in my presentation. First of all, a very brief context of the EU intervention in the justice sector in Kenya. Second, the lessons that we have learned as development partner on the effects of the COVID-19 pandemic. And third, how we intend to bring these lessons forward in the next few years as we continue supporting the justice sector in Kenya. So first of all, as a starting point, it's useful to recall that the European Union was founded on principles of rule of law, democracy, and human rights. And it's not a small feat, given European history for centuries of war and conflicts. And when we say that since the European Union was created, not a single war has taken place on the EU territory. By extension, those principles are also the key objectives of the European Union's foreign policy, and one of the central objectives of the European Union's role as a development partner across the world. We firmly believe also that the rule of law and the justice system is one of the key strengths of Kenya to firmly root the country as a modern democracy. And it's also where Kenya and the EU share fundamental values of human rights and human dignity. I'm French, and one of the proudest aspects that I carry from my culture out there in the world are the defining principles of the French Republic: liberté, égalité, fraternité. Of course, set aside the French wine and French cheese, but these are more difficult to carry around. But I think these principles are very central to the action that we are trying to achieve and to the value that I am trying to promote as an EU civil servant. So Kenya is no exception to the fact that the EU has a very strong interest in strengthening access to justice and strengthening rule of law. Since 2017, with the start of the Program for Legal Empowerment and Aid Delivery, that some of you may know as PLEAD, the EU has become the biggest donor in Kenya to the justice sector. PLEAD is also our biggest justice program in sub-Saharan Africa. We have here a budget of 4.3 billion Kenyan shillings. With this program, the EU has built excellent relations and has brought the incredible expertise of many stakeholders. In particular, here are our implementing partners, UNDP and UNODC, but not only. NLAS, civil society organizations supported through Amkeniwa Kenya, many are the stakeholders that contribute to the success that PLEAD is so far. And we work basically under 4 main outcomes. The first one is enhanced access to legal aid, especially for the poor and vulnerable. Here we work in particular with the National Legal Aid Service, and with CSOs through Amkeniwa Kenya. We also work on strengthened court administration and court case management, on increased quality and efficiency of the criminal justice system, and last but not least, on improved coherence and cooperation with the justice sector. So here, basically, we work with the whole justice, criminal justice chain in the country, in particular through the National Council on the Administration of Justice, together with the judiciary under the steering of the Chief Justice, and with the technical support of UNODC. So it's quite a wide-ranging program, and PLEAD has initiated transformative criminal justice reforms in Kenya and continues to receive strong government buy-in. On this, we count in particular on cultivating the strong relationship that we have established with the Chief Justice, first with the previous Chief Justice, David Maraga, and now with our new Chief Justice, Martha Koum. We acknowledge in particular the remarkable achievements of CJ Koum before her appointment, and recognize that in her capacity as Chief Justice, her vision for social transformation through access to justice is fully consistent with what the EU is trying to achieve through PLEAD. So what we do with PLEAD is difficult to summarize in a few minutes, given how far-reaching the program is in terms of activities. So I will not go into the details. I would just mention that this morning, as I speak right now, our ambassador is launching together with the Office of Director of Public Prosecutions and with the DPP himself, Nordin Haji, the Prosecutor's Guide on Children in Criminal Justice. Quite recently, in June, we have also supported ODPP by delivering a boat in Lamu County to support the operationalization of courts, including mobile courts. This is just one of the many examples of what we are doing in the different focus counties. PLEAD has also supported the development and now the implementation of the Alternative Justice Systems national policy. I heard earlier that some of you are champions of this. The EU is also a champion of AGS system, and we're very proud to have supported the development of this national policy. And then PLEAD is a very strong partner of the Judicial Training Institute in supporting the development of training materials and the delivery of training on various areas, ranging from active case management, bail and bond, plea bargain, diversion, etc. We support as well the National Council for Administration of Justice to improve the coordination overall of the institutional setup for the administration of justice in Kenya. On public trust and confidence, PLEAD is also supporting the development of a sector-wide anti-corruption strategy. And last but not least, of course, on legal aid, we are delivering key support to the National Legal Aid Service and to the many civil society actors involved through Amkeniwa Kenya. But let's get back to the topic at hand. I have 8 learned lessons that I would like to share with you today from the perspective of a development partner. Here, starting with the reference framework that we use as donor, and that we call the AAAQ framework, which sets the standards for effective public service delivery. It refers to availability, accessibility, acceptability, and quality. So this framework, we try and apply it to all the public services that we support, and I think is particularly relevant when it comes to access to justice and legal aid. So in terms of the lessons from the pandemic, we saw that COVID was a test of strength and resilience. With it, we saw that the justice system in Kenya was resilient, but we also saw even more strikingly how COVID has aggravated some of the challenges that already existed before the pandemic, but also how it has created new opportunities. So lesson number 1, what has been particularly remarkable was the adaptive capacity of PLEAD during the pandemic and how the implementing partners were able to reallocate resources to specifically address some of the challenges that emerged directly from the pandemic. So resilience and flexibility in the action from development partners is the first lesson that we draw. And here we have to commend in particular the excellent work done by UNODC and UNDP. Second lesson, COVID-19 has increased the prevalence of gender-based violence, reaching some alarming levels in the previous months. And here we realize that maybe we haven't looked enough at addressing access to justice for victims of gender-based violence in this action that we had designed. So here we think that there is a need to look at this more closely and to make sure that there is better access to prosecution, to redress, and to effective justice for victims of gender-based violence. Lesson number 3. COVID-19 has also highlighted the issue of prison congestion and how poor conditions, in particular poor sanitation and higher risk of exposure to infectious diseases is particularly present in Kenyan prisons. Prisons are at the same time becoming fertile breeding grounds for radicalization, as well as recruiting grounds for organized crime, and thus posing a high risk to the safety of citizens in the long term. In contrast, alternative justice systems, and in particular alternatives to imprisonment, offer a proven way to facilitate the social reintegration of offenders. Lesson number 4, and this has been already mentioned several times this morning, COVID-19 has demonstrated the use of technology as a crucial enabler to improve access to and to improve delivery of justice. If there is one silver lining from this pandemic, it's the increased uptake, forced by all means, of digital technologies in the justice sector. It allows for continued service delivery while ensuring the sanitary measures of COVID. It offers efficiency gains and cost savings in a sector which remains crucially challenged by funding issues. Last but not least, it can be more inclusive and allow for a safer delivery of justice. We heard, for instance, from women victims of gender-based violence that the fact that we have online proceeding and that they don't have to face their offenders in the same physical room can allow for a safer and improved access to justice for these women. But also, there was a very interesting point that was made by Lady Justice Wasilwa this morning and by Flora as well, on the fact that there are serious operational challenges coming from digitalization as well, and that we should have in mind the digital gap and making sure that we do not increase the digital gap when we go with digitalization of the justice sector. So all in all, digitalization is a silver lining of the pandemic, but it's definitely not a silver bullet. The uptake of technology, and that's the lesson number 5, is also evident when it comes to training and capacity building, for instance, with the development of e-courses and online solutions for legal education. In the case of PLEADS, such e-courses sought to address the challenges of the pandemic with a special emphasis on human rights. And through our program, we have already reached out to more than 22,000 enlisted legal officers through online training. Lesson number 6, and I think one of the most critical, is the necessity to consider better the needs of vulnerable groups. I already mentioned the women victims of gender-based violence, but here we should also mention children and persons with disabilities. So here again, going back to this issue of the widening digital gap, how can we ensure better accessibility of legal aid and justice for the most vulnerable, to make sure that this leaving no one behind mantra does not stay an empty promise. The lesson number 7, I'm almost there, is the continued need for legal aid and working both with duty bearers and with the representatives of the rights holders. Duty bearers, we have, again, the National Legal Aid Service today, and the CSOs for the representatives of the rights holders, which are supported through Mkiniwa Kenya. We saw, again, during the pandemic, how there is a critical justice gap amongst the most vulnerable, for which legal aid assistance interventions are necessary, and how important it is for duty bearers and rights holders to work together. So in the future, we will have to improve also how we ensure that this connection between duty bearers and rights holders is done. And last lesson, it's the increased importance of the fight against corruption. And I think this is also one of the key priorities of Chief Justice Martha Koum when it comes to restoring or strengthening trust and confidence in the justice system. We saw it with COVID and with the case of KEMSA and public procurement of PPEs. If we want to enhance public trust and confidence in the justice system, we need to fully empower the justice system to effectively investigate and prosecute corruption. So, with those lessons, I'm happy to share with you today that we have, as EU, finalized the design of the PLEAD 2 program, and we have just secured the funding for the second phase of this program, which will start probably around early 2023, as soon as we are officially done with the first phase of PLEAD. Here again, we're making a statement as European Union, because it will be our biggest individual financial commitment on an individual bilateral action in the next 5 years. Here we're talking about a budget of almost 4.5 billion shillings. So, some guiding principles for this new program. Of course, we want to build on the achievements of PLEAD and to expand further. We want to retain the holistic approach with the whole judicial chain, acknowledging that the judicial system is only as strong as its weakest link. Second, we want to continue and re-emphasize the focus on vulnerable and marginalized groups, in particular women, again in relation to gender-based violence, but not only, children and persons with disabilities. Third, we will have a much stronger focus on the fight against corruption. We will work in particular in integrating in our PLEAD action the different bodies dealing with the fight against corruption, in particular the EACC, but also the National Police Service and the Office of the Attorney General. Then we will have a much stronger focus on digitalization as well, but not as an end in itself, rather as an enabler of justice, keeping in mind this risk of increasing the digital gap. Then we also want, of course, to continue supporting the efforts of civil society and improve their relations with the duty bearers. We also want to expand the scope of our actions in the justice sector from 12 counties that we have at the moment under PLEAD to 20 counties. Then, last but not least, we also want to improve the coordination with the other development partners. So we have our implementing partners that will remain UNODC and UNDP, but we also want to work more closely with the others, in particular IDLO, with the World Bank and other key actors that support the justice system in Kenya. So what we have ahead of us is quite ambitious, because we have the objective to finalize all of this and sign these contracts by the end of 2022, with an electoral period in the middle. But we can make it, and these will require extensive consultations with a wide range of stakeholders. And I think what we're having today as this conference is going also to be a very interesting starting point in terms of all the expertise and the intelligence that academia is bringing in, and that we will certainly take on board when we design more concretely the actions of PLEAD. So again, congratulations for this event, and I hope to see you again next year for the third national conference. Thank you.
Thank you very much to my friend from the EU. I congratulate you for the support you continue to give, but my fear, and you'll correct me if my fear is misplaced, you give a lot of support to national initiatives. And from my experience, when support is given without an exit strategy, the day you decide to leave, that is when those initiatives collapse. What are your strategies beyond the period that you are supporting these programs so that Kenya as a country is able to carry them when you choose to withdraw? Thank you.
Last in the first round of question. Okay, I think then you can give the mic to her as the first person to answer.
Thank you for the questions. On accreditation of the paralegals, we are in talks with the stakeholders to come up with the rules of engaging these paralegals. First of all, we need to know, as CLE has explained, who is this paralegal? So we are in talks with the Council of Legal Education to first understand how do we go about it. Should we just take anyone being called as a paralegal? That is what we are avoiding. We want to come up with a system that will allow us to accredit those who we feel are the right persons to deal with those who will be receiving legal aid from the National Legal Aid Service and the accredited legal aid providers. As for the advocates who will be accredited, those are talks that we are having with the Law Society of Kenya in order to agree on which is the best way to engage them. We want a system that will succeed. There was one that we had where we were paying 10,000. The fruits of that were not the best. So we are in talks with the Law Society of Kenya to agree on how best to engage these paralegals. On the Huduma centers, thank you for that. We already have some offices allocated to us by the Huduma Center. They have offered us that nationally, and it is an offer that we have accepted. It's a question of now delinking, being able to recruit in order to have the personnel to send to the various centers. But Huduma Center, I agree with you, is a very good starting point to render services, especially in the marginalized areas and areas that are highly populated. Thank you.
Thank you. Mary, do you have any question for you?
No, maybe just to clarify, the mandate to accredit paralegals is with the National Legal Aid Service. The mandate to accredit paralegal education providers is with the Council of Legal Education. There's a little bit of regulation of paralegals under the Law Societies Act, but I don't know whether the Law Society of Kenya would be able to do that because of the definition of who the Law Society of Kenya can regulate.
Thank you for the question. Really good question, and I think it's at the heart of the questionings that we have as development practitioners in general, and not only to this program. But first, I would say that we have to recognize that when you work on governance, rule of law, and democracy, you have to acknowledge that changes don't take place overnight, and that when you engage in this kind of sectors, you have to look at the long term, and you do not necessarily see results on the very short term, at least within the lifetime of a given project. So when you engage in a sector like that, you have, and when you build relationships with stakeholders being governments or non-state actors, you have to acknowledge that you're not in there for the short run. These are long-term partnerships that you're trying to build, and I try to emphasize that we have also a political interest for it. But this issue of exit strategy and sustainability, of course, is central. So first of all, I could tell you that we have in our project design, the way we decide our financing decisions, in the quality review of the project, we have very strong considerations in terms of financial sustainability and in terms of institutional sustainability of the different initiatives that we support. Second, when we deliver the funding, we try to build capacities of the beneficiaries who receive the funding. And for those of you who have experience managing EU funding, let me tell you that you learn very quickly building your capacities. I see Flora nodding. This can be very challenging for new institutions in particular. So there is also a learning curve, and we hope that with EU funding, you build also your capacities to manage. Last but not least, it's the policy dialogue. When the EU engages itself in a sector like this one, and when we put so much money on the table, we also buy our seats at the table with the national governments to engage in policy dialogue with the governments. And that's where we value very much the relations that we have here with the judiciary and the different actors in the government. It's because we can also advocate and ensure that the justice sector is given the attention that it deserves and it's properly funded. So in short, these are the main points. Thank you.
Okay, let him be joined by Mr. Baron. All right. And then after that, okay. Thank you, thank you. Thank you so much. All right. So then after that, they can just say something out. So, Prof, you can put on your mask and then now say something. We must make sure that we don't expose you. Oh yes, and that new strain.
This is Egerton Law Journal, published by Egerton University. ISBN number 2789 3421, volume 1, 2021. It's available to the world of knowledge. And I think this is a good milestone. We have been waiting for it. It is a dummy, big enough, big knowledge that we require. And I think this means if you need knowledge, you need legal knowledge, you have a lot to get from this. Congratulations to the faculty, congratulations to the UNDP, and everyone that has supported this. Among you and others, some editors. Here, one of the editors here. What is here is authentic to the legal mind. Thank you.
Mr. Baron? Okay. Asante sana. Okay. Yeah, so we can give another round of applause as they take their seat. Thank you so much, ladies and gentlemen.
Essentially, what the UN subcommission was trying to establish there is in what possible ways can international solidarity, which is a fundamental principle of international law, be crucial or be the basis, the foundation for the promotion of human rights. And on this very day, there are committed efforts of translation of international solidarity as a principle into a right. For example, in the category of right to development, right to peace, right to democracy, the United Nations human rights system is known for norm production or overproduction of human rights norms, some of them that may not be in the classical or the orthodox sense that we know them, such as the right to freedom, right to freedom of movement, and so forth. So this new breed of rights that is emergent in the United Nations system is causing a lot of starting a lot of debate and opposition, particularly from the West, but we'll come there. So currently as we speak, there is a United Nations declaration in the mold of the Declaration of the Right to Development, the Declaration of Rights of Indigenous Communities. So the UN Declaration of International Solidarity as a Human Right of 2017, very, very recent, that recognizes that international solidarity can be a human right like any other to promote the rights of those most vulnerable. Solidarity is required in circumstances such as in global pandemic where health justice is needed, development where development justice may be needed, global migration, refugee protection, fighting poverty, which is an aspect of social justice, climate change, which seeks environmental justice, in the case of fighting populism and xenophobia, race and racial discrimination, and so forth. These are some of the challenges to humanity where international solidarity is required. So the argument that I adopt in this paper is that international solidarity is observable in different contexts, whether in the EU, the UN, and the AU law. For example, if you look at Article 27 of the AU Charter, various aspects of the UN Charter as well demonstrate that international solidarity is actually a fundamental principle. And so at the point when the UN is recognizing that the right to international solidarity anchors global partnerships, allowing international commitments to be nurtured and advanced to address common challenges. So this is a right that is addressed to common challenges, specifically targets common challenges that I've mentioned there, whether they're in the sense of global pandemics such as COVID-19, whether in the realm of development, refugee protection, in the sense of fighting poverty, where you see global partnerships and cooperation for development, in climate change, the principle of common but differentiated responsibilities, and so forth. Now, of course, I don't want to go to bog it down with a lot of jurisprudence, the question of what solidarity means, but we can have that discussion there. But I think the most important emphasis on the principle of international solidarity that founds the right to international solidarity is the emphasis is always on the common good of humanity, which in this case now displaces the emphasis on the state and the individual, based on the recognition that effective realization of human rights is a community interest and not necessarily a state or individual interest. So as I've said, there is a draft UN Declaration on Human Rights and International Solidarity that gives a basic framework or an outline of how this right should look like. It first defines international solidarity as the expression of a spirit of unity among individuals, peoples, states, and international organizations, encompassing the union of interests that I've talked about, purposes and actions, and the recognition of different needs and rights to achieve common goals. Now, the right to international solidarity, that is to say, recognizes that there could be certain common challenges that the global community faces, where there need to be what we call synergy of interest concerted efforts to alleviate those challenges. In Article 4, it defines the right to international solidarity as a human right by which individuals and peoples are entitled on the basis of equality and non-discrimination to participate meaningfully in, contribute to, and enjoy social and international order. This is how the right to development is also defined, by the way. So these solidaristic rights are always rights of individuals and peoples, and not necessarily of individuals alone. And people's, the expression of people can be on their own or a group of people such as indigenous communities and minorities. Now, as I've said, the proposal for the adoption of the the right to international solidarity has faced certain fierce objections at the UN level from 2004 up to 2017, when they were looking into how this right should be adopted and by the international community, primarily because of the various epistemological paradigms within rights are construed or conceived. For example, for the West, so at the UN level, the European Union takes a different dimension from what Southern or scholars or representatives of countries from the South, their position. Their viewpoint is that there could be certain challenges to the global community whose solution may not necessarily be found within the traditional conceptual paradigms of human rights. Traditionally, rights are construed as being counter-sovereign, counter-statist, and being individualistic. Now, that excessive individualism and counter-sovereign conception of rights may not particularly work for this new breed of rights that seek the vindication of minorities, groups, people who are facing structural challenges in the global economy, for example. So the right to international solidarity, if expressed in the fight against poverty, which requires global partnership, is a right not directly targeted against the state, or cannot necessarily be enforced against the state only. It should or can be enforced against the global actors in the development field, such as transnational corporations, the international financial institutions. And yet, traditionally, these institutions are not addressees of human rights. They're not duty bearers in the strict sense of the word, or in the conventional sense of the word. So that explains why the objections to these new rights is rife, particularly from the North at the UN level, because of the traditional conceptions such as that rights, in the words of Jack Donnelly, that rights are instrumental protections against the state, and that any other conception of rights which deviates fundamentally from the Western liberal paradigm is actually a cynical manipulation of tradition. You recall, for example, that at the time when socioeconomic rights, around 1990, Cass Arsenstein was writing against the enactment of socioeconomic rights in the Constitution of Eastern European countries, and he called them actually a mistake, perhaps a disaster, because these rights impose new obligations that are untraditional, they are unconventional, and requires certain affirmative actions on actors. And those actors are not necessarily the state. There have been comments from the West such as these rights are imprecise, and indeed these rights are imprecise. Those who have read the Declaration of the Right to Development very, very keenly, you may not clearly know what is the import or the definitive import of what that right entails, in the same way as the right to international solidarity. So they are claiming that these rights are normatively and conceptually imprecise and vague, because they embody an idea that is somewhat dissimilar to most human rights principles. And here the idea of dissimilarity they're talking about is that international solidarity as a right deviates from and does not necessarily comport with the traditional conceptions of right in the sovereignist and counter-sovereignist sense. So yeah, and I think that's a part of the reason why there was fierce resistance to the idea of the right of development, which was embraced more by people in the global south. Because, as Makau Mutua emphasizes, the counter-sovereignist account of human rights may not necessarily be broad-based, in that even in the traditional sense, in the African sense, the origin of the state is not that quite clear as the Western liberal thought would want us to believe or imagine. The Western position is that, you cannot actually ascertain who the duty bearers are and who right holders are. And that these are moral rights which are not necessarily enforceable. That is the Western position at the UN level. But I think the Southern position is that there ought to be a recognition of new criteria of rights that can be applied or can be deployed in new circumstances where the global community faces a lot of challenges. One of them is the right to international solidarity. The right to international solidarity expresses the need or the imperative of the global community coming together and having a sense of obligation to fight the common challenges, whether it's COVID-19. And I'm going to demonstrate in what ways has the principle of international solidarity been deployed in fighting the global pandemic or taking certain measures towards addressing the global pandemic. So the Southern perspective, which is mostly people from developing countries and not necessarily the North, advocating for new breed of rights that address the very roots of the challenges that they face, whether in the realm of poverty, in the realm of environmental justice, for example, who becomes the duty bearers in circumstances where the levers of power are lopsided. I don't know whether I can possibly explain this in 20 minutes. Yeah, so that is exactly the Southern position, the UN independent expert, that is Professor Vera Okafor, taking the position that obligations underpinned by the norm of international solidarity transcend state borders, as these obligations are owed to the international community by both the state, individuals, civil society, transnational actors, and so forth. You can move to the next. So I think the position that I also take is that these emergent rights, that are associated with the expansion and are constantly focusing the human rights agenda at the level of norm practice to address the phenomena of a global scale that pose threats to to humanity. Yes, and there have been questions in the same way that non-Western conceptions of rights have been questioned. I will jump from the slide number 11. Let's go to the next. So slide number 11 talks about what are the roots, what are the legal foundations of the right to international solidarity in the international normative system. You find it at Article 55 of the UN that talks about the duty of cooperation and partnership or assistance in promoting and respect for human rights, in the UTHR, in the International Covenant of Economic and Social Rights, and so forth. So we will not discuss that, probably on the 2030 Agenda for Sustainable Development. But in the context of COVID-19, the argument here is that while we may still question the root or the heritage, the pedigree of the right to international solidarity, practice on the ground or praxis on the ground shows that this right is actually being felt, or practices of various actors are promoting the realization of the right to international solidarity in the context of COVID-19 and in other contexts. Move to the next slide. Yeah. Next again. Yeah, COVID-19 tools in which was convened by the World Health Organization and other partners, aimed at accelerating the development and production of the vaccine and access to the vaccine, which has raised quite a lot of money, 5.6 billion and so forth. I can move to the next step. The COVAX facility aimed for pulling up resources and ensuring equity in the distribution of vaccines, though that's still a debatable question. The COVID-19 Solidarity Response Fund. These are aspects of various aspects of global partnership that shows international solidarity as a principle, and that furthers the realization of various rights, whether the right to health, the right to food, particularly in the context of COVID-19. COVID-19 Solidarity Fund, that's the next slide, in which the World Health Organization, the United Nations Foundation Initiative, in partnership with the Swiss Philanthropy Foundation. And the fund does support quite a number of projects. The UNHCR has contributed and so forth. These are various expressions of international solidarity. Of course, international development banks such as African Development Bank, Inter-American Development, and the World Bank as well has contributed funds in various ways to various countries, poor countries as well. There's expressions of international solidarity for the furtherance of human rights of those most affected and the most vulnerable. Regional initiatives such as those of the AU, putting in money in the tune of 270 million and so forth. ECOWAS as well, having a special fund. This research may not be necessarily theoretical. State-led actions and aid, such as Cuba exporting traditionally its healthcare workers and doctor aid as in the human aspect of human capital to assist various countries. And they have sent these doctors to, including the Western countries such as Italy, by the way, and Spain, which are the declining powers of Europe, as you may be aware. Critical supplies from China, Russia, including trainings of professionals. Those are aspects of international solidarity that furthers the realization of rights of the most vulnerable, the most affected people in the third world. Various aspects of state-led actions, those of China, which shared virological information on the emerging virus. India and South Africa applying for exceptions or waiver for compulsory licensing and so forth, so that they can produce cheaper and affordable drugs. So there's still a lot of injustice, of course, in the vaccine, COVID-19 vaccine, that probably may not necessarily be addressed. But my point was just to address in what ways is the right to international solidarity being realized as a principle that founds that is the basis of the foundation for the promotion of rights of individuals. Multilateral interventions by G20, however genuinely founded they may be. Yeah, so I'll stop there. And I don't know what is the next step.
So good afternoon, ladies and gentlemen. As you've heard, my name is Damaris Barsitau. And first things first, I want to thank my colleague and friend, Dr. Ruth Aura, for this kind invitation. And of course, I'm delighted to meet everyone. My presentation today is based on an ongoing research project sponsored by Michigan State University on violence, gender-based violence among school-going girls in Narrow County. It's also based on my own ongoing work as a social justice educator working with Let Maasai Girls Learn, which is my personal initiative to take Maasai girls to school and, sort of fight for their reproductive health justice. And also, the work is based on evidence-based policy research on women and girls and the impact of COVID on those two constituencies, which I often publish with the Brookings institutions where I serve as an Egerton Global Scholar in girls' education. So really lots of data in this, but I'll just try to talk into just a few points that I think are critically important for this research today. And my topic has changed a little. So now it's titled Robbed Dreams, or Economies of Violence, the COVID-19 Pandemic, Religious Contestations over Teenage Pregnancy, and the Quest for Reproductive Justice in Kenya. I don't need to belabor the impact of COVID-19 on all aspects of our lives. So across every sphere of life, the novel COVID-19 pandemic has had and continues to have devastating consequences on all people globally, but especially women and girls in developing countries. First, the COVID-19 pandemic has massively disrupted women's lives in every area of their lives and has threatened to wipe out and unravel decades of progress towards women's rights and gender equality. And of course, COVID-19 has impacted boys, but data shows that women and girls are disproportionately affected. And while in Africa, we haven't seen the number of fatalities that were initially projected, it doesn't mean that the impact has been any less severe. We have seen women's lives disrupted in every imaginable area that you can think of. And African women and girls especially continue to bear the brunt of the unprecedented pandemic that has not only further exacerbated already existing gender inequalities for millions of these vulnerable constituencies, but also one that has laid bare serious fault lines in respect of gender equality, education, research, and policy. And I will outline a few policy gaps sometimes, if I have the time. In Kenya, as well as much of the developing world, there has been an unparalleled explosion of teenage pregnancy during the COVID-19 pandemic. But even before that, even before the pandemic, there has always been, really high numbers of teenage pregnancy in the country, which I personally think it's unacceptable, for us to grapple with that kind of data, that kind of numbers of, teenage pregnancy. And we saw that during the 2018 examination period, when unprecedentedly high numbers of teenage girls were giving birth during the examination period. And I remember the Minister of Education then, Amina Mohamed, the Honorable Amina Mohamed, really raising the red flag about this, disturbing scenario. But of course, girls from extremely marginalized areas, like where I come from, I come from Maasai land, and that's why I have an organization to have to take girls to school, because they encounter tremendous challenges in their quest for education. So, teenage pregnancy affects girls generally, but girls in situation of vulnerabilities, in situation of poverty, in situation of just just the sheer distance to school from villages where, if you have been to Kajiado or to Narok County, you would know how schools are so widely spaced, and that poses serious health challenges to girls. And the data again is damning. Between July 2016 and 2017, the Ministry of Health recorded almost 350 pregnancies among young women aged between 15 and 19. Similarly, and according to the Kenya Demographic Health Survey of 2014, 18% of women aged between 15 and 19 were mothers or pregnant with their first child. Yet the subsequent lockdown measures by the government in early 2020 robbed thousands of teenage girls of not just their dreams, but also their right to education, reproductive justice, and gender justice. And so this paper examines the explosion of teenage pregnancies during the lockdowns, the contestation and quest for justice and rights for marginalized girls in Kenya. It reflects on the status of vulnerable girls, quest for educational justice in Kenya and beyond. And of course, the theoretical framing for this paper is based on the concept of reproductive justice. And the statistics are there. You can see, according to the National Council for Population Development, the national teenage pregnancy prevalence rate in Kenya is 18%, which is quite high. 1 in every 5 school-going girls get pregnant by the age of 20. And he has raised the issue of what age is proper. I won't get into that because I'm not aware. And I don't want to be sued by anybody. But I think it's scary to anybody, especially to a mother like myself. Rates increase rapidly with age, from 3% among girls at 15 years old to 40% among girls 19 years old. But the situation varies across counties, with some counties seeing higher rates than others. Even in Nairobi itself, the numbers of girls that get pregnant are concentrated around, informal settlements or the most vulnerable of populations. Almost the same with rural areas. But girls from, middle class and, those other classes that I don't want to talk about, the numbers are really, they vary depending on the demographic situation of the parents. An increase in the adolescent pregnancy rate strongly suggests challenges with accessing sexual and reproductive health care services for this vulnerable age group, and is a cause for concern. Now, I'll speak briefly about the gender effects of the COVID-19 lockdown, particularly, just giving a bit of evidence-based data on teenage pregnancy. As I said before, that the COVID-19 pandemic intensified existing socio-economic inequalities while also creating new ones in its way. And we haven't even begun to grasp the true impact of the COVID-19 situation. And one of the things that I grapple with as a researcher is the sheer lack of, not just ethnographic data, but real evidence-based data, particularly during the pandemic when nobody could go anywhere to do anything. And my other researches and policy briefs continues to show the paucity of data when we think about issues to do with a situation like this. The data is just not there, or when it's collected, then we don't get to appreciate the full impact of that. First, there has been this significant rise in teenage pregnancies, with about 152,000 reported. There is contestation around that. Throughout the lockdown, social media, there was just so much sensationalization about that. There was so much exaggeration. Some people are saying, in Makueni County alone, there were 4,000 teenage pregnancies. In Kakamega, there were 5,000 or something like that. And that masks, the serious problems that we need to be tackling in. The sensationalization, I'm sorry, I'm going to chew my tongue saying that word, you'll forgive me. But when things are exaggerated, people don't get a full appreciation of the tensions on the ground. But also there are There's also a serious lack of, even before the COVID-19 pandemic, Kenya was already struggling with reduced funding for reproductive health services, as well as limited sexuality education in schools. And part of that has been the religious contestations around reproductive health issues. We saw during the population conference in Nairobi in 2019 how the religious sector put up a very spirited fight to fight the introduction of comprehensive sexuality education in schools, access to abortion, and access to reproductive health technology, or in other words, maybe family planning. And that has had a serious impact on young girls, especially, who are not only able to access these services, but also there's just so much stigma created by religious organizations around some of these things that are supposed to support girls' reproductive health lives and their intimate sexual lives. At the same time, there are cultural taboos around talking about sexual health at home, which has left many Kenyan teenagers reliant on their schools for reproductive health knowledge. Parents don't talk about these things. I say that knowing that I'm also a parent, I try to talk about it. But it's a taboo subject. Where I come from, it's a no-go zone. Nobody talks about that. So girls are left, without the skills and the tools to be able to navigate their intimate lives. Yet teenagers also do not receive the necessary education for pregnancy prevention, because the sex education curriculum mainly focuses on HIV/AIDS prevention and abstinence as a result of influence from religious leaders or the religious sector, or faith-based leaders, if you like. Kenyan students also, according to one study, do not have access to even limited sexual health education while they were in the lockdown. I mean, many people could not access information. Teenagers were also not able to access the kind of education that would empower them with the skills and the right acumen to be able to navigate their lives. And the result of that was an unprecedentedly high number of teenage pregnancy, which is blamed on this gap. There's also been significant sensationalization, I finally got it, and spiritualization and moralization of teenage pregnancies by religious leaders and other conservative groups in a way that I find problematic. Yet teenage pregnancy in Kenya disproportionately affects girls in various situations of vulnerabilities, namely poverty, girls in rural areas and marginalized areas, girls living with disabilities, and girls in refugee situations. I think I began by talking about my research methodology, but you can access some of my works there. I was saying that this paper is based on my own ethnographic data. I'm an ethnographer, so I collect data through speaking to people and doing interviews and focus group discussions and just participating and seeing how people go about their lives. And the research is still ongoing. It's not been concluded. It's still ongoing. As I speak, some students are on the ground continuing to collect this data. According to the 2015 Kenya National Bureau of Statistics Adolescents and Youth Survey, teenage pregnancy is one of the leading causes of school dropouts in the country. The scenario is also replicated in Kajiado and Narok counties and many other marginalized counties. And we can have a debate about marginalization until the cows come home. But if you come from where I come from, then you understand what marginalization is. And as I said, I work with Maasai Girls Education, and I was able to generate just so much of ethnographic data through phone interviews during the lockdown. And now that the country has opened up, we are on the field collecting the same data. Much of the evidence-based research was undertaken during the COVID-19 lockdowns on the impact of the COVID-19 pandemic on women and girls, including some of my own works that I have cited there. And it's also, as I'm thinking about teenage pregnancy in Kenya, I keep having these questions that run through my mind. How can we locate teenage pregnancy within human rights and reproductive justice discourses? How do we center access to reproductive justice as a way of mitigating teenage pregnancy in Kenya? How can evidence-based research inform interventions to mitigate teenage pregnancies while supporting teen mothers to get back to school? I find this critically important given that there is a paucity of data, evidence-based data, that should inform policy on how we can make interventions for marginalized girls. And this is especially important given that for many teen moms, pregnancies often signals an end to their education. Once young girls get pregnant, that's in most cases, almost 98% according to some data, signals that those girls will never go back to school. And although we have reintegration policies in Kenya that a girl can go back to school, the reality on the ground is completely different. It's just impossible for that to happen. And I know that based on my own personal experiences working with Maasai girls, sometimes I've had to go to talk to parents and give them incentives to take care of the children so that the girl can go back to school. But how many girls can I support to do that? So it's a real problem. There are many drivers of teenage pregnancy, and I won't belabor all of them, but generally there's poor literacy levels, particularly in counties where literacy levels are extremely, I'm going to confuse myself, where very many parents in Kajiado County are just not educated. They are unable to read or write, or in Narok County. So when you have situations like that, then girls are disadvantaged. There is lack of comprehensive sexuality education. This has been, a tug of war between religious leaders, conservative groups, and parents who do not want to have comprehensive sexuality education taught in school. In other parts of the world, comprehensive sexuality education and access to sexuality knowledge, as well as reproductive health technology, has ensured that fewer girls fall victims to early teenage pregnancy. Another driver of teenage pregnancy is lack of sexual and reproductive health knowledge and rights. Violence against women and girls is also another, big factor in teenage pregnancy. And the UN has declared that the pandemic, the lockdown was, gender-based violence is another pandemic on its own, and the statistics are also damning about what goes on. But in the case of the girls I work with, there are many other issues like rape, child sex trafficking, FGM, early forced marriage being reported throughout the lockdown. And I also noted that in Nakuru. Lack of access to contraceptives, and of course the stigma around that for young girls. At the same time, there are lifetime consequences for teenage pregnancy. These girls never get back to school, and they continue to reproduce legacies of poverty upon poverty when they are not able to complete their education. So it's not just about education loss and loss of education opportunities, but also that even their own children will continue to live a life of poverty. I'm going to jump that just because I have very little time. But I wanted to really speak about the religious contestations. In recent but contestant debates and discourses about the causes of teenage pregnancy, religious leaders, cultural conservatives, and policymakers have blamed these girls and their parents and guardians for teenage pregnancy. Even the Minister of Education, Professor Magoha, has blamed teenage girls, for getting pregnant, and he blames the parents for allowing the girls to get pregnant. And I think the question for many of us social justice activists is, how do you blame girls for getting pregnant when they lack the tools to navigate their intimate lives, which often coincides with the time when teenage girls are really undergoing their own biological development. It just makes sense to empower girls to be able to understand what is going on with their bodies. But when they are blamed for something that we have not given them, I find that completely unjust. And so, those of us in social justice education are trying very hard to see how do we influence religious clergy to be able to, come to the table and discuss about these crucial and important issues. I'm about to be evicted from here, but let me just say that religious clergy are becoming increasingly influential and vocal on a wide range of social and political and spiritual and policy issues in Kenya, including gender rights and justice, women's bodies, and sexual citizenship. These clergy are not only increasingly using this power to assert religiously conservative positions over public policy and political issues, but are also increasingly shaping and perpetuating gender norms and inequality, including policing of women's bodies, intimate lives, rights, and sexual citizenship. And I speak about that in a different paper. I'm jumping and getting to, I think, the most important thing here is the need for, a quest for reproductive justice for girls in this situation. And I think some of the recommendations that I make is that all stakeholders, particularly in the Ministry of Education, and now my legal fraternity here, must be able to design interventions and sustainable solutions to this worrying trend. And a good place to begin is to ensure that introduction of comprehensive sexuality education in school curriculums is taken care of. Now I'm going to stop before I'm sorry. In conclusion, I can supply the slides for people. I think in Kenya, teenage girls experienced and continue to experience the unprecedented effects of the COVID-19 pandemic, and yet we continue to blame them. But there is also need for us to send our discourses on teenage pregnancy around social justice issues in Kenya. Thank you very much, and I'm sorry for the time I have taken. And that means you don't ask me questions because I've already eaten on my time for questions. Thank you.
Professor, there is a question coming to you. It will come. I listened to the President of the Republic of Tanzania yesterday. She said that now they have allowed girls who do their standard 7 exams but fail due to the pregnancies that they have, they are allowed one chance to repeat. So that means maybe previously they were never given a chance. If a girl conceived, dropped out of school, that will mark the end of it. But in Kenya, we have seen that even when they are in hospital, in the labor ward, they are given exams. I think we should appreciate that we are now promoting fundamental rights of the young people. Right. Dr. Thank you so much for that presentation. But we will have a few minutes for you to answer a few questions, including the ones you avoided about the law. But you can ask the lawyers. Now, next, we want to listen to Professor Patricia Kameri Bote, Professor Collins Odete, Dr. Robert Kibugi, and Khadija Yawa, who have sent a representative by the Professor, I'm still wondering.
Good afternoon. As he sets up, my name is Susan Yara. I'm here to represent the professors from the Faculty of Law, University of Nairobi. So, I think, Mr. Kevin, you've received my presentation. Okay. So now we are looking at access to education during the COVID-19 pandemic in Kenya, and we looked at the law, the realities, and also the innovations. So basically, if you read our abstract, we gave a summary of how the COVID-19 impacted the world at large, the human health, and also caused fatalities across the globe. And then now we are talking about the right to education as one of the socio-economic rights that were affected by the pandemic. So in Kenya, education was one of the early victims of the pandemic when the schools were closed. And this disrupted learning, obviously across the globe, and Kenya was one of the countries. And this, basically, it worsened a crisis that was already there, because we know all about education inequalities. And then from there on, we had debates on what is the appropriate balance between the right to health and the right to education, in that which one comes first. Is there one that supersedes the other? Should we put one above the other? Or now they should all be equal rights and they should be protected? Yes, things like those. So now there were a couple of cases in courts in so many countries, and Kenya being one of them, and we shall look at those cases. So now, one of the responses that came about was online learning, which has definitely been there, but now with the COVID-19 pandemic, it was really improved, since more and more schools were trying to uptake emergency learning. And so now there is a very, very good case where now we shall see these balances trying to come out, but then unfortunately there was no balance in this case. That was in the High Court, and that was the case of Joseph Enoch Ora. Yes, I will talk about that case. So now we go to the right to education and its implications for development. We see that the UDHR affirms every human has the right to education, and this focuses on the realization and the strengthening of respect for human rights and fundamental freedoms. So now we have education, the right of education as a basic human right that should be accorded to every child in the world. And this right, it should be protected by the state ideally, but not all states have been able to protect it, mostly in the developing countries. And also we have the UN Convention on the Rights of the Child, all about free education in the elementary stages, and also now pupils getting also education at the universities and so on. So now education has been seen as a bridge now which closes the gap between the rich and the poor. And we have seen that there are so many people from humble backgrounds who have been able to make it in life through education, me being one of them. So there was this study, and then they're saying that children who are from poor backgrounds, when they succeed in their schooling, then they have better chances at elevating their socio-economic statuses. And education is then termed as a social elevator. You know, now like a stairs, you're now going through the stairs, getting education, and then you'll get at the pinnacle where now you'll get your success in your career. That is if you like education. But then if you fail, then that's another matter. So now we have two authors here who say that attaining education as a mark of social status by transitioning to adulthood, and that is the main avenue of upward mobility. I know some of us have taken economics, maybe at one point in our lives, and we know all about upward mobility. And then we also have the right to education in SDG 4. And then we have, a general comment, number 13, on the right of education by the CESCR. Basically just reiterating what I've said, education being a human right and also indispensable, and it's used as a means to realize other human rights. So now in the last sentence, if you can see it, it says increasingly education is recognized as one of the best financial investments states can make. And then when now COVID-19 came, it's really negatively impacted on education as a socio-economic right. If you see there in that image there, we have the number of pupils who are affected by the total closure of schools and also by the partial closure of schools around the world. And the World Bank says that more than 681 million students were affected. And then we all have seen the negative impacts that have been experienced by the closure of schools. We had dismal performance, we had educational inequities, which are already faced by students from disadvantaged families. And also there was the shrinkage of economic efficiency. And then we know that some schools offer feeding programs to children, so now these children were not able to get their nutrition. And then the Human Rights Watch also talked about mental health, which we have all seen. And Dr. Damaris has also talked about the gender issues, which emerged. And then also there was the rise in adolescent pregnancies. Yes, all that. So now you see there is really no good which has come out except now the improvement of online learning. So now and the introduction of virtual learning, there is a quote there. It says that barriers to quality education are still too high for too many learners. Even before COVID-19, 1 in 5 children, adolescents and youth were entirely excluded from education. Stigma, stereotypes and discrimination mean millions more are further alienated inside classrooms. So you see, virtual learning in Kenya could not be afforded by all learners. That's because mainly we are a developing country, and also the internet was expensive for some learners, and also there were network issues, and also the affordability of smart gadgets. So now, on to the crux of the matter is that we need to strike a balance between the national responses to COVID-19, that was the right to health, and also the right to education in Kenya. Once now there was closure of schools as one of the responses to COVID-19, now the children were forced to remain at home. So as a consequence, the right to education was made unavailable. And despite the president allocating a surplus of 6.5 billion as part of his 8-point economic stimulus program, still not every student could join the e-learning. So this increased the education inequality in the country. So now this is the case, the next case for Joseph Enoch Ora versus the cabinet secretary. Mainly, the petitioner brought the suit to court, complaining about the prolonged closure of schools, and also the president's address to the nation closing the schools. And then the court held that although the address by the president was constitutional, still the schools needed to be reopened. So now here you see that the court missed a very great opportunity to balance these two rights. Mainly they were like blowing hot air and also cold air. Yes, the directive is constitutional. Now this directive to close the school. But then on the other hand, schools should be reopened. Isn't this some sort of confusion? They could not come out outrightly and make a balance of these rights, which is also, the balancing of rights also improves on sustainable development. And this was a chance that they would have had now to balance the two rights and see that none supersedes the other. And even though the right to health is important, the right to education is also equally important. So that could have set jurisprudence, and also it could have set some good precedent on how to deal with pandemics and other rights. So now, and then the second case that we have, basically, it was just talking about virtual e-learning and how different stakeholders reacted to it. And also we have a case in Malawi, where now the court said that closing a school is unreasonable. As long as there are health guidelines in place, then schools should remain open. And then we also have a case from the state of California, that is Brach versus Newsom. The governor went ahead to order the closure of schools as a health response to COVID-19. But then the Ninth Circuit Court of Appeal said that this was unconstitutional and that parental rights over education should be left to parents and not the government. So you see, now that is very, very different from what is happening in Kenya. Yes. So, and then we also have a South African case where the court said that it was unreasonable to close schools when there are already safety measures in place to curb the spread of COVID-19. Yeah, so now they were saying that it was an unreasonable and irrational choice to close schools. Then we go to the performance of the judiciary and also the innovations, the techniques, and the tests applied by various courts. We saw that this pandemic, it brought about some changes in how the judiciary has been making its decisions. So now we have them looking at the balance of probability. We have courts looking at the precautionary principle, necessity, proportionality, the rule of law, legality, reasonableness, and also solidarity. Yes, and we see that there was this nature of competing rights, which has now totally changed the way that judiciary looks at socio-economic rights in terms of the pandemic, when now the pandemic started. So now the first one is the degree of necessity, and that case I've already talked about it, the Joseph Enoch Ora, is that it was necessary to keep schools open, but then it was also necessary now to safeguard human lives. And then we have the application of proportionality, and we have the general comment number 14 by CESCR, where now they're saying that the right to health is closely related to other rights and also to the realization of human rights. Yes, and there we see now we have the rights and the freedoms, right to food, housing, work, education, human dignity, yes, and also the freedoms of association, assembly, and movement. So now we have this case, JMK and 3 others versus Kenyatta University, Referral and Research Hospital. When the court applied proportionality, and basically these petitioners wanted their bills waived because the government had said, okay, yes, you shall be treated for COVID-19 at no cost. And then now they were being charged, and then they wanted conservatory orders. So now it was held that the conservatory orders that they were seeking was not proportionate to the financial damage that would result if public health facilities were told not to collect treatment fees from COVID-19 patients. And then we have the reasonableness. In this case, what happened is that when the judiciary was on a slowdown and not everyone could access justice from the courts, now this Ranjit, he had applied for an appeal, but then, and also he had sought for the court documents, but then they came late. So now, and the other party was saying, but you are locked out due to time lapse, so no, you cannot appeal. So the court held that yes, they can appeal because COVID-19 is the new normal, and that it really affected the way that courts did their work, and so yes, he was allowed to appeal. And then we have South Africa. Yes, they used principles of necessity, separation of powers, reasonableness, etc. And then there we have a case where now the applicants wanted the alert measures to be, the alert level 4 measures to be reinstated by the court, since now the government had reduced from level 4 now to level 3, and also the government wanted to reopen schools. And also this other case, also from South Africa, the university students refused now for the university to be closed, and so they wanted the university to test these students for COVID-19 and ensure that now they are safe to be, and now ensure that they are safe to be let out into the community. And then we have the balance of probabilities in this Malawian case. Yes. And then here we have something from France. France actually, the courts in France, they were really into getting scientific evidence, scientific studies, when now these COVID-19 cases were being taken to court. Yes, so now they were saying that these decisions have to integrate scientific standards so as to see whether they will open or whether now the government should open schools or now these schools should remain closed. So now here we have some recommendations. It's that courts can do better in the management of crisis, and we have seen now different jurisdictions being able to balance between the right to health and the right to education. And also there is need to adopt the digital tools, and also there is need for cooperation within the judiciary and also interinstitutional cooperation. And then we need to consider realistic and practical solutions when applying the law. And also we look at constitutionalism, the rule of law, and protection of human rights to ensure that now we are able to balance these human rights and one does not suffer at the expense of another. And also we need to appreciate the enforcement in times of pandemic or emergencies. And also we need to look at the role of transparent information and accountability, and also the issue of scientific evidence as what France is doing. And what I talked about, the need for judges to develop a criteria for balancing different competing rights. Yes, and also we need to look at SDG 16. Yes, and also promote the use of the precautionary principle. Yeah, basically that's it. But my part in short would be that there is need now to balance these rights so that one right does not suffer over the other, and that there is need now for the court to develop a criteria so that the duty bearers cannot only protect one right at the expense of another. Thank you.
For allowing me to speak, but I have two responses. First one is it was very nice to listen to my teacher, Professor Lumumba, making a call which I think is useful for African governments to be able to pay the bill. I think that's an important point. It's a point about us being responsible for our action. But I disagree a little bit with my teacher when he says that if you don't pay the bill, then you have to speak, especially talking in the context of socioeconomic crisis. Applied Professor Lumumba to his logical conclusion, it will mean that those of us who are poor should not be able to speak because it is economics that gives you the voice to speak. And I think that for me, from a justice perspective, is stretching it. I think we should talk about people paying, but we shouldn't say because you don't speak, you cannot be able to speak. You don't pay, you cannot be able to speak. That will be allowing the West to trample over us because we are poor. That will be dangerous. The second point is the question that was asked about the courts. And I think the presentation that was made by Susan, that Professor Lumumba asked about balancing. If you read the case Professor Lumumba, the court did very well by saying, you know, the president was right in terms of closing the country. But then they go ahead and say, but in this instance, we want them to go ahead and open for kids to go to school. Our problem with it is that in an instance where the court was confronted with the issue about how do you balance the two rights, what are the criteria you provide for balancing in terms of an health emergency, the court shucked away from that responsibility. And our proposal is that it is important that there is guidance when their two rights are in conflict to say, in this instance, provide let this happen before you go to the next stage. I think in this current state, the court should have actually have said, looking at the two rights, the right to education and the right to health, which of those can we be able to give slight preference to? And out of the context of the health emergency, I think the first preference should have been given to health, to say, no, we will allow what the government has done, but provide for an opportunity for the ministry to be able to engage with stakeholders to provide alternative mechanisms for opening. That's what we would be suggesting. But I think in this instance, the court actually blew hot and cold at the same time, Prof. Lumumba, as he used to tell us. They give in one hand and take in the other without providing for mechanisms for balancing. I hope that answers your question. Thank you very much.
He was asking why now there is lack of predictability in these court decisions amid the COVID-19 pandemic. We all know that we were all shocked by the COVID-19 pandemic. There was lack of
preparedness. And so we have seen some countries being successful in balancing these two rights. So now what these courts need to do, they need to take lessons from now these comparative experiences from these countries which have been successful. And we also need to set the criteria to balance these rights now as one of the steps now for high-level preparedness. Yes, I hope I've answered your question. Thank you.
Good afternoon.
I kindly request that you be very brief.
I am usually very brief. My name is Ogada. I want to echo what Professor Lumumba said in terms of African autochthony and African knowledge. In terms of even dealing with the question of socio-economic rights, sticking to the Western paradigms of balance, proportionality, and other balance tests from the West do not give us the real thing if we stick to those notions as important to us. Briefly, if we look at, and I'll speak to this tomorrow, the South Africans have a unique balance test as regards socio-economic rights, and particularly with regards to eviction, whereby they look at the elderly, the children, households headed by women. And these are criteria used when balancing and giving a decision. These criteria resonate with us as Africans. So let's not take what the West gives us, hook, line, and sinker. And the West's interest is to make me a better French, a better Englishman, a better Lusophone. For heaven's sake, my name is Ogada. I come from Kisumu. I'm as black as everybody can come from Africa, and I'm proud of it. Thank you.
Now we have the final question.
All right. My question is, I guess, posed to the entirety of the people who've been asking questions, especially in relation to the courts, because it seems to me that we are tending to treat the courts as the policymakers and as the people who are making the law, rather than their role as interpretation. Because you hear somebody, for example, say that the courts should do this, which to me doesn't really fall under their laws. That's extending beyond the scope of their jurisdiction within the Constitution and within the law structure. So just want to point out that the court's role within the platform, within the system, and within the country, as I see it, should be on interpretation of the law in relation now to the parties in front of the courts. So I guess maybe I'm a bit isolated from, I would say maybe the realities are a bit different. But to me, it seems rather concerning when somebody views the courts as the decision, as the policy maker, as a lawmaker. I was just pointing that out.
All right.
Something interesting.
Okay, thank you so much. Now, for those who have made their presentations, thank you so much for your presentation. Those who have reacted, those who have participated, all you are welcome. Now, my time has come to an end. Mr. Kyoko, I would kindly ask you to take over. But as you take over, the tradition is between me and you have to answer this question. This is the question. Why is it that a man who commits a female crime has to be sent to his mother? No.
Why is it that a man who commits a female crime is sent to his motherland? We'll have that over a cup of tea. All right. Thank you so much, everyone. We want to bring this to a close and call it a day.